Recording in progress.
You have a good Monday?
Oh, yes.
I thought you would.
Except that my husband thought he had a guy coming to help us with our solar system, so I put makeup on and clothes. I said, otherwise I might.
Good evening, everybody. It is January 21st, 2025 at 5 p.m. We are here for a special session of the Harney County Court. And the court session is now in session. If, as usual, everybody would stand, please join me for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Dominic, just so you know, here at the table, myself, Commissioner Frank, Commissioner Doro, Planning Director McMullen, and Executive Assistant York, and we have one member of the public press, Barb Candy.
Okay, thanks.
So, first thing up, opportunity for public comment. I don't have you another public, but it's candidate. Okay. General discussion, determine if executive needed. Basically, we are here based on the guidance and our county ordinance is to, look at the appeal filed in the matter of the Gilmore petition, an application for a non-farm dwelling, and the appeal filed by Mr. Inglis in objection to that granting of that conditional use permit. And this evening we can take one of several different actions here. One, to decline to hear the matter and enter an order affirming the lower decision of the Planning Commission itself. Or accept the appeal, which if we do accept the appeal, then we'll have to schedule a public hearing. And in that public hearing, then we can make a decision on the record without argument, make a decision on the record with argument, conduct a de novo hearing, or conduct a hearing limited to specific issues. You get all that right, Brendan?
You got it.
Okay. As this is kind of unfamiliar territory for the county court, and the last time it was done was about 10 years ago. I'm not really sure how to proceed here, other than I'll just open it up for discussion. Commissioners?
No.
We have a special session.
Oh, cause I'm like, that was on Thursday.
That one is.
Okay, fine. Have a great time, everyone.
Well, I think I'll just mention some things that are in the guidance on what this is about. And I want to thank Planning Director McMullen for providing us all the materials, as well as access to the recordings and the PowerPoint that were what the Planning Commission, Harney County Planning Commission, had and used in their decision. And then it was emphasized during their meeting that this is a quasi judicial process, and our role and duty on appeal is to review the facts and the evidence to determine whether or not all criteria are met with sufficient specificity for the application or not. The appellant, has things that were brought up, but we have to review how factual and how evidentiary the information is, and then either support and uphold the planning commission's decision or to proceed on and potentially overturn their position. So think about facts and evidence, not necessarily personal viewpoints, opinions. When we look at what the material presented was, I'm pleased to say that it was there was plenty of time after the hearing and before the final ruling, at the 3 7-day periods for the processes of people and the applicant and the appellant, to all provide additional information if needed. And we're just supposed to think about the clearest and strongest points that drive a decision on this matter. So that's all, just some general comments.
Commissioner Frank?
I feel like the appellant thoroughly refuted at least 3 of the 4 criteria, and I've gone through this a couple times, and a lot of times in the 2 meetings that we have the audio files for, they refer to 4 criteria, but I don't think they are listed 1, 2, 3, 4 in our zoning ordinance. That's not the way they're listed, but if I just say the 4 criteria, everyone knows what I'm talking about. The 4 criteria of changing the use of the land, the fact that the parcel was made before 1993, those 4 criteria. I can dig it up if you want me to.
Sure. Are those points or from the appeals documentation? There are many more than 4 criteria. So
I know there are, and just several times in the planning commission meetings, the 2 that we had access to the audio files for, they specifically refer to the 4 criteria. And so that's what I kind of focus on. I was trying to flip through these 1,000 pages because I know in the packet like you make for the planning commission that has each of the ordinance sub-level out, that's what I was trying to find. But when I read through that original appeal, I felt like in several of the areas, the appellant made a compelling case that they did not meet those criteria. And for example, the home site is unsuitable for the production of crops and livestock. It's been traditionally used for that in the past. I worry about the precedent that this will set, which maybe that gets into some gray area that Dominique can comment on. But the precedent that this would set if we do approve non-farm dwellings on parcels such as this, in this information, the proponents of this non-farm dwelling say that there are no other comparable parcels within the study area, but the opponents or the appellant say that there are at least eight other small parcels. And so it worries me that not only in this area, but in other areas, if we approve non-farm dwellings because there is a small portion inside a parcel that's land class 7 or above, then we may see changes in development trends. I know that was one of the things talked about with these criteria is the development trends in Harney County. There haven't been a lot of development on those kind of parcels, but you got to beg the question, is that because we have been sticking to our comprehensive plan and our zoning ordinance and haven't been approving those? I have questions about it, and I don't feel like I can say with 100% confidence that I would.
And if you will, the things you're talking about to me sound like deliberations if we were actually hearing it again rather than kind of. So we may need to ask Dominic about that.
So the decision we need to make tonight is to decline to hear the matter and enter an order affirming the lower decision or accept the appeal. So those are the 2 things. If we were to decline to hear it, we basically make a decision and it's over with at this level anyway. If we accept the appeal, then we'll set a public hearing.
Well, you know. Just like you two, I take it very seriously, was very. Detailed in how I reviewed everything. And I think, all right, this sounds good, and then I'd hear the other side, but then I remember, we have to look at evidence. And we have land use, zoning, and criteria to be met. And we have a planning commission that does its job well, I believe. And so at this juncture, because, you'd hear, well, the land, soil study says this, and, other people say this, etc. How much of that is evidence? How much is that is, if you can remember to keep a quasi judicial hat on in this, at this point, when we're getting ready to make a choice on what we do, I think we need to do that. Planning staff's recommendation I take seriously as well. That was that all the findings in the planning commission's decision are supported by the facts and substantial evidence and information submitted into the record by the applicant. A thorough and proper review process was provided by the county planning commission, in which they voted. There was one abstention, but it was unanimous other than that to approve the application. I know some of the people on that commission, and they're very strongly in favor of keeping ag land in general in ag. Yet also the reason that we have conditional use permits in our statutes, in our ordinances, and in our practices, the fact that there haven't been much development on houses, nothing in 20 years, and etc. And that this particular landowner has, quite a bit of land, but found the exact place that had the least suitable land for agriculture. Then what is the impact to the appellant? We heard things, how evidentiary it was is another matter. So anyway, that's kind of how I ended up viewing it. I tried to keep in that lane.
And I would agree, and that's why either you feel that the record is substantial enough to decline to hear the appeal, and we affirm the planning commission's decision, or we feel that there's not sufficient information in the record that we would need to conduct our own hearing to hear that information and adjudicate that information. Let's say something else. Lost it.
There are some parts of the code that are referenced by the appellant that I definitely would not feel comfortable declining to hear an appeal, particularly the parts that talk about the water parcel should not be considered unsuitable solely because of the size or location if it can reasonably be put to farm or forest use in conjunction with other land. And the other sub item after that, one of the things that I've thought of, and I don't know how much we need to weigh possible future implications and what the past tradition has been, but I know in the time that I spent on the planning commission, when we have these non-farm dwellings come through or conditional use, it didn't come up because the neighbors that were notified didn't have anything to say about it. And to me, that's a big difference between these two. If no neighbors had any objections, then that implies that that parcel of land couldn't be used in conjunction with the other surrounding farming operations. So I would be in favor of hearing.
So I want to clarify that in granting the conditional use permit for a non-farm dwelling, does not remove this zoning classification for this property out of EFU.
Correct.
It still is EFU, we're just allowing or the process, the permit would allow a non-farm related dwelling on that EFU land.
Exactly. It approves a single family dwelling and accessory buildings that are affiliated with it. It doesn't change the underlying zoning designation. It can't change taxes, of course, but any improvements can.
Well, I feel like we could hear it all in another hearing, the three of us, but I don't know that we, except by our position, can overrule something. Would have any more reason to decide differently than the planning commissioners who do this as a matter of duty regularly, unless we are trying to send a message about our values and whatnot, and I don't know that's appropriate in an application. If they meet the criteria, I'm trying to be really evidentiary here, not what I kind of want to do, but what I should do.
Yeah. Well, and I've wrestled with the same concept, is that what we have before us today and what we have to think about and consider is the record that's before us. Is that record sufficient to make a decision tonight, or is it not? Am I on the right track, Dominic?
I think so. I would say it is a little open-ended. I mean, there could be different considerations for each one of your options, right? I mean, I think if, like to decline to hear the matter, I think would be, yeah, that you think the record's sufficient. I think also, though, it's still appropriate, to look at the appeal, and if you didn't think the appeal had merit, that would be, second reason to choose A, to decline to hear the matter. As far as your options under B, the four options, I mean, you do have the authority to make a different decision from the existing record. I think what I hear Commissioner Doro saying is like, well, this is what the planning commission's for. We'd have to maybe have a good reason why we'd want to make a different finding on an issue than what the planning commission did. They're the ones that heard the oral testimony live, etc. But again, I mean, if there's a particular issue or particular ground for appeal, one of the things I heard Commissioner Frank talk about was, what this finding about, and the appellant raises this, whether the area was unsuitable for production of farm crops and livestock. I mean, I have no opinion about the merits of it, but if that was something that the majority of the county court thought, yeah, we'd like to hear more about that, then the county court would, they could decide, well, we would like to hear the parties' arguments about the existing evidence, or you guys could decide that you want to hear a new hearing on that specific issue. So, I mean, there's a number of considerations that I think are appropriate or legitimate. I think ultimately it comes down to, how much merit that you see in the appeal and whether that warrants for further hearing on the appeal.
So again, this is kind of uncharted territory, and I'm just bouncing something off the wall here. If the designation of the land does not change, if it stays EFU, then the fact of whether or not the land is suitable or not suitable for agricultural production is kind of moot, isn't it? Because we're not changing the zoning of the land to non-production because it's non-suitable. Under EFRU 2 classification, it still retains that capability.
So the EFU zones and the rest of the zoning designations that we have in our zoning ordinance have a list of permitted and conditionally permitted uses. None of them are inherently going to change the underlying zone designation that's applied to the parcel. It's whether or not the criteria that are meant to be met to establish that particular type of use are fulfilled in the application review process. And so in the end, I don't know if this is the best answer to your question, but in the end, the request from the applicant doesn't change the zoning designation of the land. It is, in simplest terms, to get a single family dwelling on a parcel that is under the minimum lot size necessary for dwellings in conjunction with agriculture, or what we call farm dwellings.
Yeah, I agree with that. And I guess Judge Hart, I guess I just, and well, and Director McMullen, correct me if I'm wrong, but I guess I feel a little compelled just to make sure that we're framing this correctly, because while I think what Mr. Director McMullen said is correct, and I think what you said, Judge Hart, is correct. The way I read the final decision and the criteria is that, like, in order to get the permit, you know, different criteria have to be met. And my understanding of this particular criteria we're talking about, it states that the dwelling is situated upon a lot or parcel or a portion of a lot or parcel that is generally unsuitable land for the production of farm crops and livestock or merchantable tree species, etc. So, I mean, regardless of whether the zoning is going to change, I think what the appellant's argument is that that finding that this portion of the lot is unsuitable is incorrect. So I think if the appellant carried their burden on that issue, say at LUBA, then they could get remanded.
Would a decision for the county court to decline to hear the matter, still allow the appellant to appeal to LUBA?
Yes. Yeah, it would basically, it'd actually speed up their LUBA appeal, because that would create a final decision by the county at the county level, and then that would be what they would need then to go on to LUBA.
So then is LUBA then going to reverse, or could they reverse the decision of the planning commission? Or are they just gonna turn around and remand it back to the county court or the planning commission for greater review?
Well, it depends. So this gets into the issue where I start talking about things that might be more appropriate for executive session, but I'll say this. I mean, it depends on exactly how they dispose of the argument. I mean, it is difficult to get factual findings reversed on appeal in general. So usually if there's evidence in the record that supports a finding, that won't get reversed. You know, but so if it got reversed, that could send it back to have the application be denied. You know, if they thought there's some other maybe problem, or maybe that certain evidence was ignored or something like that, then they might remand it back for further consideration. Those are, I mean, that's examples.
And Dominic, this is Brandon. If the decision was to if our local decision was then sent appealed to LUBA, and LUBA's decision was to remand back to the county for whatever reasons, the county would then decide if the planning commission wanted to hear this on remand, or the county court as the appellant body could then hear it on remand as well. So it doesn't, and there's no direction in our zoning ordinance that I know of that says on remand, the planning commission is the hearing body. I would, it's always, since I've been here, that's been the county court, but I wanted to pass that by you.
Yeah, I think that's probably right. I mean, on the one hand, we kind of cross that bridge that if we ever got there, but I tend to agree because they were the final decision maker. Unless there was something in the code or ordinance that said otherwise, I think that the county court could be the decision-making body, because ultimately it's their final decision that would be appealed to LUBA that incorporates the planning commission's order, if they adopted it.
And then if it gets remanded back to the county court, are they gonna specify the issues in question or in consideration, that we then would only have to look at those specific points that they remanded it back to us for?
They would have, yeah, typically they would do that, because essentially the appeal, you know, like maybe it raises more than 3 points, but there's 3 or 4 main points raised by this appeal, and usually they would be limited to those issues to raise to LUBA as well. And so the appellant will carry their burden on each of their assignments of error, and LUBA would address, they're very actually pretty pretty thorough about addressing each assignment of error individually. And they would identify, if there was an error, they would identify what that error was and what needed to be addressed on revamp. That's been my experience with LUBA matters.
That's certainly been the case in the previous cases, so to speak, with Harney County's involvement since I've been the planning director.
I think I'll make a motion, see what happens with it. I move that the county court decline to hear the matter and enter an order affirming the lower decision. No, you're the second.
I will second. A motion has been made and seconded to decline to hear the matter and enter an order affirming the lower decision. Any further discussion?
Just that, if the appellant further appealed up to LUBA, and if it got remanded back, then I think we ought to be the ones to determine should that happen, but at this point, I didn't find any fault with the planning commission in this matter.
Myself, I would agree at this point, looking at the record that's in front of us. I can't find any reason with the record and the appeal and the conditions or the items of appeal. That would take me in another direction.
As I previously stated, I think that more than one of the criteria are adequately refuted. And I tried to think back, if I were in a different situation, if I were on the planning commission, I think I would have made that same argument there. I think that these matters are really serious because if someone purchases a piece of property that's zoned EFRU2, it's with the assumption that there are not going to be houses on smaller parcels around them. And if there is a change to that with conditional use, then we change their value of their property, the existing property owner, their intrinsic value and possibly the extrinsic value if there is more development and it changes tax rates. But I also feel like my colleagues have gone through the material thoroughly, and I think this one is right on the edge. Just for me personally, I feel like I would like to hear an appeal, but I'll dang sure respect the decision of the court.
Yeah. No, I hear you. I mean, I took several days on it.
Yeah, and I don't want to get too far beyond what's in front of us. I mean, I think it was incumbent upon myself or each of us to do our due diligence in looking at the record in front of us and using that to decide our decision tonight. I mean, I've asked questions to try and understand this process and kind of understand historical practices within Harney County. But again, it's incumbent to come back to what's in front of me. And with what I see is in front of me, I'm leaning towards the decline to hear. Without making an actual vote at this time. I mean,
So we moved and seconded.
I moved and seconded, and I asked for any further discussion.
I call previous question on unfinished business.
What's that?
I call previous question on unfinished business, the vote. If there's no more discussion, because we can vote on, can't we?
Yes, yeah. So with that in mind then, all in favor signify by saying aye.
Aye.
Aye. All opposed?
Nay.
I would ask for abstentions, but that takes care of all three of us, so. Motion carries 2-1. So,
Okay, I guess for my purposes, do you need any assistance for preparing the order? Because the ordinance calls for an order.
Yes.
declaration.
Yeah, and I talked to Dominic, I talked to Brandon about that today and asked him if we should have an order here present today to be able to sign, which we don't, and he said that he would coordinate with you. So then will we just need to take that up in our next county court session to sign it?
Yeah.
Okay.
Okay, yeah, it's maybe been a while, Brandon, but if you do have an example in the past, that always makes things a little easier, just if you've got something that maybe you've used before.
Yep, I'll be in touch. We gotta talk about something else too, so.
Okay,
Thank you, sir. Appreciate your time.
okay, thanks, bye.
That being the extent or the purpose of our special session tonight, and being no further business, I shall say county court will stand adjourned. Thank you.
The gentleman is downstairs, the meeting that's starting right now on, from LCDC on the sage grouse mapping and,
Yeah, John.
yeah,